welcome and good evening, friends. Today we will be discussing the paper of Advocacy and Professional Ethics. I, Jay Savla, and my esteemed colleague Deepak Nargolkar will be addressing today. Mr. Arun Rashad Gupta last week has very eloquently explained the art of advocacy. He has also explained the skills required for a successful lawyer. He's also gone through some Bar Council rules. So our endeavor is to help you to prepare for the forthcoming exam. Now, for the purpose of this exam, that is the Advocacy and Professional Ethics, what we basically need is Advocates Act, Bar Council rules, Supreme Court rules, part of Evidence Act, which deals with privileged and professional and confidential communication, Contempt of Court Act, Civil Procedure Code to the extent it deals with ADR, that is alternate dispute resolution, and of course material on the art of advocacy. Now let us start with the Advocates Act. As you know, all of you have studied the professional ethics in law college, so it's not a new subject. But as you know, the Advocates Act consists of only 60 sections. However, it is very important statute for us because it is Advocates Act which gives us right to practice. And it is Advocates Act under which an advocate can be debarred from practicing. So therefore, Advocates Act really assumes significance for the purpose of our practice. The Act is divided broadly into 7 chapters, but we will be focusing only on the relevant chapter. Chapter 2 of the Advocates Act deals with State Bar Council and Bar Council of India. What are the roles, functions of State Bar Council and Bar Council of India? They are specified in Chapter 2. Chapter 3 deals with admission and enrollment of advocates. Now, there are 2 types of advocates mentioned: senior advocates and other advocates. For senior advocates, Bar Council of India has separate rules, which are restrictions, which provide for restrictions on senior advocate. That is Chapter 3. Chapter 4 is our right to practice. Once you are enrolled with a state bar, you have a right to practice. This is just introduction. Chapter 5 is what is really important for us, and which is conduct of an advocate. And Chapter 5 will start from Section 35. So if we look at Section 35, it provides for punishment of an advocate for misconduct. What is misconduct? That is not defined in the Act. We have come across service rules under labor and service law, where there are major misconduct, there is minor misconduct, and there would be punishment in accordance with the misconduct proved. But under the Advocates Act and under Section 35, I do not see where the misconduct is defined. Now, Section 35 deals with 2 kinds of misconduct. It can be professional misconduct or other misconduct. The powers of the State Bar Council: once the Bar Council is of the opinion, that means it has a reason to believe that a case prima facie is made out of a professional misconduct or of any other misconduct, then it would refer a case to disciplinary committee. Now, what are the powers of disciplinary committee? Disciplinary committee can either dismiss the complaint if it finds no case made out, or it can reprimand an advocate. It can suspend the advocate for a particular period of time from practicing, He can also revoke license. These are the powers available with State Bar Council under Section 35. Now, what is misconduct is subject matter of interpretation by various judgments. Broadly put it, if an advocate acts against the professional ethics or against the code of conduct, then he would be guilty of misconduct. Let me give you some examples. For example, as an advocate on record, client has given you an advance amount. You know for a fact that matter is not going to come up for another 3 to 4 months. You have utilized that money because of some emergency. Now, if you have utilized the money, which is given in escrow or on trust by an advocate, it would amount to gross misconduct. And that is what Supreme Court has said, that you are holding the amount of your client in trust. Any misappropriation would be a gross misconduct. Even a negligence. If an advocate is negligent in performing its duty, it would be an act of misconduct. Now, what would be a gross negligence? Let us take an example that you are an advocate on record and a client has come to you with papers to file special petition. The client has approached you well within time. After the certified copy, you have 90 days and client has approached you in time. For some reason, you have not been able to file special petition within time and the SLP is dismissed by the Supreme Court only on the ground of delay. Would in that case, an advocate be responsible and would be held guilty of professional misconduct? According to me, yes. He would be held guilty of misconduct because this is an act of gross negligence. Giving a wrong advice, would that be an act of misconduct? Let us test this. For example, as we all know, if a will is to be attested, an unprivileged will, there has to be attestation by 2 witnesses, and both witnesses have to sign in presence of each other and in the presence of testator. As an advocate, if this important part is missed out and only signature of 1 witness is taken, and the will is disproved in court of law on this ground, then in my view, this would be a wrong advice and negligence on the part of the lawyer. But for example, if we file Article 32 petition for violation of fundamental right, and the Supreme Court is of the view that why have you come to Supreme Court? You exercise the rights available under 226 and go to High Court and has dismissed the petition. That may not be a wrong advice, because in many cases, the Supreme Court has exercised their power under 32. So the aspect of misconduct would vary. Similarly, soliciting a client is also not permitted. Let me give you an example. When I was advocate on record for about 20 odd years, during June vacation, I go to Bombay High Court, meet my friends, and of course the lawyer friends will introduce me to their friends. As a result, the advocates do know that I'm practicing in Supreme Court. I met a colleague who told me that what practice he follows is, he checks the list. Now we get online list, but earlier we used to get hard copy. So he would check the advance list, and wherever a party's name is mentioned without advocate's name, and if the party is a corporate or a company, he would check the ROC site or the website of the company and address letter to the company that, look here, there is a special leave petition or a civil appeal filed against you or against the company. And if you wish, you can hire our services. Would this amount to soliciting work? According to me, it would amount to soliciting work because you are directly approaching a client for purpose of getting work. An advertisement, similarly, would also be an act of misconduct because it is in breach of the professional duty. In one case, Supreme Court held that a client came to a lawyer for a case before a particular judge. Lawyer told the client that there is another client of mine who knows the judge very well. So if you pay me X amount of money, your order is guaranteed. Now, please never indulge into this practice. This is absolutely wrong practice, unethical, unpardonable. This is a gross act of misconduct. It is our duty to uphold the administration of justice. Similarly, many times the original documents are kept with lawyers. After the case is over, a lawyer cannot keep the original documents even on the ground of non-payment of their fees. Supreme Court has clearly held that the documents are not goods, the case papers are not goods. You cannot keep goods in your custody. You cannot exercise your right of you are bound to return the papers or original documents to the client, irrespective of whether your fees are paid or not paid. Otherwise, it will again amount to an act of misconduct. There are clients who will come and say, look, I don't have fees to pay, but subject to result, I'm willing to pay you the fees. Now, this would also amount to an act of misconduct because you cannot charge fees which is contingent based. So these are some of the examples of misconduct. Depending on the gravity of misconduct, the punishment is imposed. Depending on the severity, the punishment is imposed by the Bar Council of India or by the State Council, as the case may be. Now, what if a lawyer misbehaves in court? If he uses intemperate language, he tries to browbeat the judge. He wants to scandalize the court proceeding. In such case, the Contempt of Court Act would trigger in. High Court or Supreme Court or even District Court on a reference to High Court can punish the advocate for the act of contempt. If an advocate has misbehaved in court, it would be not only act of contempt which is punishable by the court, but it can also lead to a disciplinary inquiry by Bar Council of India. So a particular act can invite an action under Contempt of Court Act, and it can also invite an action of suspension of Bar Council license by the Bar Council. Now, Section 35 talks of not only professional misconduct, it also discusses other misconduct. Now, what is other misconduct? Let us take an example. Supposing a lawyer, after arguing the case, comes out of the court and he starts abusing the opposite counsel outside the court premises, but within the court precincts. Would that amount to other misconduct? Or he starts in a physical fight, an assault. According to me, this would amount to other misconduct. And he can equally be punished by Bar Council of India for his misbehavior. When a Bar Council of India or State Council is deciding a complaint, what is the degree of proof which is required? Is it on a preponderance of probability, or is it to be proved beyond reasonable doubt. Because eventually you are dealing with the advocate's future and career. So Supreme Court has held that little more than preponderance of probability is required. You don't have to prove your case beyond reasonable doubt, but at the same time, little more than preponderance of probability to prove the guilt of a lawyer is required. Now let us see the other provisions of Chapter 5, which deals with conduct of advocate. I have discussed misconduct, professional misconduct, other misconduct, the punishment by the court, the punishment by bar council. And if we see Section 36 of the Advocates Act, it gives disciplinary powers to Bar Council of India. Now, Bar Council of India exercises two jurisdictions, original jurisdiction and appellate jurisdiction. The original jurisdiction is exercised when State Council, State Bar Council refers the case with an opinion to the Bar Council of India, or if a party wants it to be referred to Bar Council of India, or suo motu, Bar Council of India can take the case to itself and decides the case. That will be in exercise of its original jurisdiction. Similarly, Section 36 also provides for an appeal from an order which would be passed by the State Bar Council. So Section 36 has both original jurisdiction and appellate jurisdiction. Now, the appeal from the order of Bar Council of India would directly lie to the Supreme Court of India. That is Section 38. What is important is who can file an appeal. And it says any person aggrieved by an order by the disciplinary committee of the Bar Council of India can file an appeal. Supreme Court in one of the constitutional main judgment has discussed this provision, and it held that any person aggrieved would include even Bar Council of India, because ultimately we have to uphold the dignity of court. So if the order is wrong by the disciplinary committee, even a Bar Council of India can file an appeal in Supreme Court. So that is provided in Section 38. Section 40 deals with stay of the order. Mere filing of an appeal is not an automatic stay of the punishment imposed. And Section 42 deals with powers of disciplinary committee. And Section 44 deals with review of the orders of disciplinary committee. So these are the provisions of Chapter 5 which are relevant for the purpose of our preparation. Now, once an advocate on record is registered with Supreme Court, we have to also look at the Supreme Court rules, because you are getting a privilege to be an AOR by Supreme Court rules framed in exercise of powers under Article 142 by the Constitution, by Supreme Court of India. There are judgments, and I'm sure all of you are aware, that an advocate on record should not be merely a name lending practice, meaning thereby that there must be an active involvement of advocate on record. He should be involved in preparation. He should be involved if the brother colleague is arguing the matter. He should be present in court. If he is merely a name lending, then the privilege can be withdrawn. What is misconduct? I have discussed, but there are two very good quotes which I would like to state. We will find misconduct in corpus juris secundum, and if I may quote, professional misconduct may consist in betraying the confidence of a client, in attempting by any means to practice a fraud, or impose on or deceive the court or the adverse party or his counsel, and in fact, in any conduct which tends to bring reproach on the legal profession or to alienate the favorable opinion which the public should entertain concerning it. And there is another beautiful quote from a Privy Council judgment, which I may quote. It is shown that an advocate in pursuit of his profession has done something with regard to it, which would be reasonably regarded as disgraceful or dishonorable by his professional brethren of good repute and competency, then it is open to say that he is guilty of professional misconduct. So these are the ideas of professional misconduct. Now, my colleague Aruneshwar Gupta has already explained very eloquently the 7 lamps of advocacy, which are the qualities of a successful lawyer, which have to be built in. I would suggest that there are further, for an advocate on record, further qualities required. Firstly, when a client comes to you, you have to instill confidence. He must get confidence in you. And you must give the comfort that you would do your best for dispensation of justice. So it's only when a client comes to you, then the other aspect of advocacy will arise. So you have to instill confidence is one of the very important aspects of art of advocacy, according to me. Drafting of special leave petition or civil appeal or criminal appeal, as the case may be, is one of the very important facets in Supreme Court of art of advocacy. Because as we all know, the Supreme Court works under tremendous pressure. And within the permissible time limit, we have to convince the bench with the merits of the case. Therefore, the focus has to be on precise drafting, on the list of dates, on the synopsis, and on the questions of law. We have to state all relevant facts. It need not be very elaborate. It should be precise. So in my view, drafting plays a very, very important role. Supreme Court drafting is very different because we not only draft facts, we also quote law. So it's a mix. A question of law is posed, judgment is also quoted. And we quote judgments in synopsis if the issue is covered. So it's an important aspect of an art of advocacy. Similarly, a mediation is an area which every advocate has to convince the client to go for mediation. So to agree for a client to go for mediation is an important art which has to be developed by every lawyer. Another aspect which is important is within the framework of law, as lawyers, we have to be also innovative. We have to give suggestion to court for development of law. So my submission is that these are also important qualities of a successful lawyer. There are various duties which Mr. Nargolkar will very shortly take over and inform. But one of the duties which I personally feel as a lawyer is duty to your office. It is your office, your colleague, your junior, your clerk, your peon, who has stood by you and who has been in your journey of success. So your duty also lies in welfare of your office. Now with this, may I request Deepak Nargolkarji to give his views, and after that, we will broadly discuss structure of paper. Deepak, over to you.
Thank you, Jay. I think both my colleagues, Aruneshwar Gupta and Jay Savla, have covered the entire field. So there is hardly anything which I can add. But given an opportunity after several decades, I am trying to do something. Actually, 4 decades back, when I was to appear for the Advocate on Record examination. The seniors, Justice Bal, Tarkunde, V.S. Desai, Phadke, all these seniors used to tell me that in paper, write what you don't practice, and that is professional ethics. And you will definitely pass. As Jay has just now said, that apart from this, the our conduct must inspire confidence. That is the first test of a good advocate on record. Because the client comes with lot of hopes. It is his last opportunity to approach the court, and after that he has nothing. So you must infuse confidence in him that you will do your best. Now, what is ethics? Ethic means character, morals, conduct. Now, therefore, character is destiny, as is said. So you have to inculcate good character as an advocate. Ask your brain what is right and wrong, and brain will never confuse you. Brain will automatically tell you don't do this and do this. Now when you rethink, then you try to find out ways not to do it. So that should not be done by you. Now we all know legal profession is a great and learned profession. Now every day in and out, the lawyer has to have capacity to listen to the client. The advocate on record especially has to deal with variety of human relations, and his metal is always tested. Now, why it is a learned profession? Because lawyer constantly pleads for justice. You will find several advocates, they say that justice has to be done, and how it has to be done, do this, and then justice will be done. Now, lawyer develops these qualities by education and training. So I would suggest that every advocate must try to get himself associated with a good chamber. Now the chamber will tell you what is right, what is wrong. Lawyer learns every day by preparing and pleading in each matter, and by sitting and watching the proceedings in the court. Just few days back, Justice M.R. Shah specifically said, don't sit in the canteen sipping coffee, go and sit in the court. When I joined the profession few decades back, I was also told that don't sit in the canteen, sit in the court. And even today, I find that whenever one sits in the court, by doing nothing, you learn a lot of things. Now, all of you, this demonetization case was going on, and P. Chidambaram, senior advocate, was arguing. If you would have gone to the court and seen him argue, you would have learned a lot in advocacy and professional ethics. The way he presented his case was, according to me, the best possible way to present one's case. You should have gone and seen him argue, and you would have learned a lot. Now, lawyer's duty is not to create dispute, but to settle it. So, in some books, you will find that he is called a peacemaker. A peacemaker. Now, few years back, when I was an advocate on record, some clients came to me. They were very rich. They had gone to several other seniors who were top at that level. But however, somebody brought them to me. This dispute was between the father and the son. And when he narrated all the facts, there was some ego problem. So I told the son, go and say sorry to your father. Because the father had instructed the bank, don't advance any loan to my son. And the bank manager said that since he is the proprietor, I can't help it. I have to send this letter to the higher office. 3 days, every day morning, I used to tell him, go and see your father and say sorry. He would say, no, sir, I am giving you this much of money. Take this and file as many petitions, as many suits, as many proceedings as you want. I would not say sorry because I was not wrong. But after 3 days of continuous harping upon him to say sorry, suddenly one day on the table, when he was having breakfast with his father, he said sorry to him. And the father changed immediately and gave a ring to the bank that I am withdrawing that letter. Now, this is what an advocate should do, because you all know that when you approach the court, justice is always delayed and you hardly get it in your lifetime. The client never sees the door of justice because the litigation goes on and on and on. Now, what the client wants, the client actually desires to hire the lawyer's advocacy and not his judgment. Therefore, in several papers, you will find these questions that the client comes to you in a criminal matter and admits that he has committed the crime. Should you take up the brief? Now he is actually hiring your advocacy. So you don't have to pass your judgment. That is the job of the judge. And therefore, you can accept any brief, whether civil or criminal, when you know that the client is not exactly correct. Because ultimately, the prosecution has to prove its case beyond doubt to get conviction to the accused. Now, everybody knows that the lawyer must have great knowledge, high mental capacity, wide culture. Lawyer must know everything about something and something about everything. Because you don't know what type of client will come to you. So you have to have some knowledge about something and at least try to develop it by that. Because see, the clients give you paper, the client gives you money, and then you can do justice to the matter by reading the matter again and again. One of the seniors specifically said that don't read the matter once, read it once, twice, thrice, 4 times. Every time you will find a different point in the matter. So one has to go into that, and industry is the key to your success. Industry is the key to your success. Industry is fortune's right hand, and without it, the armory lacks weapons. Now, such quotes you mark it and you reproduce in the answer paper, and you will get good marks. Now, what according to me, advocacy and professional ethics is not a difficult subject. And therefore, if you actually read all these, what Jay Salva has told you, acts once at least right from preamble to the end, then you are not likely to fail in your exam, because you have already put in 4 years of practice and therefore you know much more. Now, coming back to those 7 lamps. Now, all those 7 lamps are quoted for ages now, that honesty, courage, industry, wit, eloquence, judgment, and fellowship. Now, you may be asked, there is some addition to these lamps? Now, according to me, tact and courtcraft. These are the two additional lamps which you must have. The tact is, as the it suggests, you have to be tactful When the judge says something, you have to listen and change your arguments according to the view of the judge. And court craft, what the court is saying, invariably you will find lawyers talking to each other when the court's judges are talking between themselves. One of the most senior counsels of this court told me that in fact that is the time when you have to keep quiet, stand up, and try to understand what is going on in their mind. Now that is core craft. Then only you will know how to proceed further. And it is very necessary because, as you know, this is the last court for the client, and every matter is important to you. Therefore, you must do as much as you can. There was a senior counsel who would go and have a list of date on every conference. Every time you go to him, you will have a list of date prepared by him. So once I asked him, sir, last time you had this list of date, why again? He said, every time I want my fresh mind to be applied to the case. And therefore, the lawyer must try to do justice even if the heavens fall. So, all these things are extremely important in our profession. Now, let us go to our ethics. Now, you must have read several books on ethics. Now, conduct of the advocate in court. Now, all of us know what should be the conduct. Now, he has to be avoid talking to anybody in the court, the present his case properly. There should not be any haste. Maintain calmness. Do not interrupt the judge. All these things you must have seen every day in the court. Now, answer directly. Now, answer directly is a very important thing. And you may find that several senior advocates would not go and answer directly because the answer is against them. But I still remember in my very early days, I was arguing a matter before Justice Venkataramaiah, where the High Court had dismissed the matter for default and refused to restore it. So it was a wonderful case for me. I filed the SLP and I argued, and the court was convinced that all right, we'll restore it and send it back and ask the High Court to hear the matter. At the last minute, Justice Venkataramaiah asked me a question. What was your defense in the written statement? So I said, my lord, my defense was adverse possession. He said, no, Mr. Naravalkar, I would not help you. So even when I started practice, it was emphasized on me that adverse possession plea, the courts usually don't want the client to succeed on the basis of adverse possession. Similarly, auction purchase. Justice Chandrachud, Y.V. Chandrachud, Chief Justice, he would ask the advocate, who asked your client to bid? Because once you bid and take the property, the litigation starts. So, purchasing property in auction, you know that its litigation will follow. So invariably, auction purchase properties are obtained at less price with the knowledge that it will involve further expenditure. So all these things are known to you, but you have to write point by point and you can give example. Now, when you state the case, you must state the case in such a way that the court should ask you, do you want to say this? Now, this was what was taught by Ram Jethmalani. He would narrate the facts in such a way that the court would ask him that, is this your submission? And he would say, yes, my lord. But that's a big art. It's not very easy for ordinary lawyer to cultivate it. But according to me, it is one of the best way to present your case. that the judge would say that, is this your submission? Now, do not conceal adverse points. Now, how many of us usually tell the court that this is adverse, this is against me? Now, I was arguing a matter before Chief Justice of India, three-judge bench, and against me, I was for the respondent, it was an appeal. Against me, a junior was arguing, and she was not in a position to narrate the facts clearly, and she was in difficulty. Then I got up and I told the court that, my lord, my case is totally covered by this judgment, which is against me, and therefore you must allow the appeal of the other side. Now, the Chief Justice asked me, Mr. Narwalkar, are you saying that this is against you and therefore their appeal should be allowed? I said yes. So, if possible, try to do that so that time of the court is not wasted, and ultimately justice lies there only. Whether you go here and there, the court is likely to find out what is the question involved, and the court would come to that conclusion maybe after some time. So it is necessary that all these things are kept in mind by the advocate. And now, for so far as you people are concerned, it is necessary that you jot down and reproduce when it is necessary, when it is asked in the question paper. Now, what is morally wrong cannot be professionally right. Now, professional conduct in general. Now, as everybody knows that your reputation reaches anywhere first, and then you reach. Therefore, it is necessary that you must have a professional quality in such a way that everybody respects you. Now, success to be achieved at all cost should not be your aim. Now, these things have to be inculcated within yourself. Now, any matter which is going on, don't go to the press and give an interview when the matter is pending before the court. It is never liked by the court, it is never appreciated by the judges. So, you have to keep those things in mind. Now, it is you, I don't have to tell you that avoid touting, don't advertise. Now, we are going in such a way that all these things, the line is very, very thin. And therefore, you have to take precaution. But at least in the paper, you must know that what you have to write. Now, the visiting cards, you can't have visiting cards which suggest few things, X so and so, Y so, and you write all those things. It is actually not, it is actually against professional ethics. So, all these things you must remember. Now, I had filed an election petition in the Bombay High Court in my very early days. And somehow it happened that I was required to step into the witness box to say, where did I file it? Now, the case, the first election petition which I had got, I was required to return as I was one of the witnesses in that matter. So, what I would have thought, but it is necessary that you can't be a witness in the case in which you are appearing. So, I returned the brief and became a witness and went into the witness box. So, all these things, you take up any book on professional ethics, they will give you. It is all in your head, but it must come out of it when you write the paper. Therefore, you must study at least twice all these things so that they remain in you, with you, and you are able to reproduce there. Now, coming to the duty to the court. Now, see, if you see everything, there are some ways where things are overlapping due to the client, due to the court, due to the profession. There are so many things which are overlapping. Now, when you draft, now actually, if you see the old drafting methods, you have to avoid adjectives. Now, Justice Y.V. Chandrachud once had taken a matter after his retirement for settlement, and he told me, don't use any adjectives. There is nothing like vehemently opposed. He said, opposed, denied is enough. The moment you use adjectives, the court's antenna go up and they say, why is he saying, is it right, wrong? But if you simply say, that is more than enough for the judges to understand the things. Now, how to treat your opponent? Now, that also, I was very junior in Supreme Court, and there was a Bombay Tenancy Act matter, and the senior who was appearing against me for the petitioner was giving so many sections and authorities for the petitioner. And somehow, I don't know, but I got up and said that, my lord, he is misleading the court by quoting the provisions which are not required for the disposal of this matter. So the senior got wild and he said, my lord, I have never got such a compliment from the other side. This is the first time I am getting it. But how the judge reacted? The judge said, Mr. So and so, but what he is saying is right. Why are you reading all these sections which are not relevant? So it got diffused, and I had an excellent relation even after that with that senior. But I was wrong in addressing the court like that he is misleading. You can say that he is not stating the correct facts, and the correct facts are this, and the relevant sections are this. So one has to use the language in a proper way, which will not offend the other side. Now, duty to the profession, you should not envy the other side. You should not envy a person who is getting more briefs, he is getting more money. Why should you bother? You bother about your case, you do it well, and that is more than enough. Now, I had gone to the Attorney General of India, Lal Narayan Sinha, for the first time in a matter from Bihar, and I was very junior. And Mr. Lal Narayan Sinha saw me, he said hello, and he realized that the junior is not ready. He is under tremendous pressure and he won't be able to do justice to the matter by telling me the correct facts. So he gave me one instance. He said, I was in the High Court, I was appearing in a second appeal, and my client was all the time nagging me and I was not getting perturbed. No, the judge was getting perturbed. So ultimately, the judge asked him, who is this person who is nagging you all the time? You are not getting perturbed, but I am getting perturbed. Lal Narayan Sinha said, my lord, he is the same person in respect of whom there is a finding that he is dead. The judge quipped immediately, saying that, tell him I am sitting in second appeal. I can't go into questions of fact. But the way he told me this, my tension came down and I felt relaxed. This is what the senior must do to a junior. And therefore, I was able to tell him the facts, the law point, the authorities. And I felt so happy that this person is a great person. Now, you have to also inculcate these habits. Now, the advocate on record and senior advocate, they must complement each other. You will find several senior advocate on records unnecessary getting up and telling the court something. The court is never impressed by such submissions or facts to be told by a junior advocate. You have to tell the senior that it is like this. But the advocate on record feels that if I tell, the court will feel that I am thoroughly prepared in the matter. So all these things you have to keep it in mind when you have to see the duty to the profession. So other side, your friend and your senior. Now, coming to the duty to the client, there are so many cases that Jay also said that the money is entrusted to you. Actually, when I appeared for the exam, there was a paper on accountancy. And there we were required to say that we have to actually open a current account and deposit the fees of the client in the current account. And you can transfer to your savings account only that fees which you are entitled to. And therefore, you can't touch that fee unless you do everything which is required. Suppose senior, court fee, cyclostyling, filing, expenditure, you have to take all into consideration and use that current account for that purpose. Now, it is very, very necessary. Initially, we had to deposit 2000 towards cost when the appeal is admitted. Now, when it was refunded, the refund used to come in the advocate on record's name. And there was a practice of all advocate on record putting it in their own account and utilizing that amount. So the client won't be getting that 2000 back, which he is entitled to. Therefore, ultimately, that practice was dropped. Now, even duty to the client, I had a will matter in the Bombay High Court. And of course, I was very young, so the clients instructed me to oppose the will. There was no substance, but I vehemently made my submissions. And the court said that, all right, you are three persons, I will give you 15,000 of each. And so 45,000 in those days of 77. So you should be happy. So I was very happy. The court passed the order. The client came next day. They said, we don't want money. I thought they would be jumping that they got 45,000 for nothing. So they said 45,000 and all, we don't want. Now what to do? Then my senior, my father only, suggested that I should go to the chamber of the judge and tell him. So I went to him. I told him this is what has happened. He said, all right, you mention it in the at 2:45 and we'll do the needful. That time he told me that when you compromise the matter, take in writing from the client that they are ready to compromise on these terms. I said, I will definitely think it and keep it in my mind. Then in open court, he again heard the matter and dismissed it. So all these things, and you learn by such things only, of others as well as yours. So all these things are important, and one has to keep it in mind, these things, when you develop yourself as advocate on record. Now, I think I don't know how much time I have taken, but if I have some more time, I will give you a couple of examples of my own this thing. We had a neighbor, and the neighbor had a mother who was 90-year-old, and he called me. He said that I have to make her will. I said, all right, you come. He said, no, but I don't know whether right thumb is to be taken, left thumb. So I said, let me talk to her so that I will know. She was not well and she was on some saline or something. So I went there. Then I noticed that probably she is no more. And her son wants that we should take her thumb impressions and prepare the will of a dead person. I said, look, this is never done. I won't be a party to such thing. You do whatever you want. You take thumb impression, go to anybody. Don't come to me because I won't be able to do this. One more interesting example I will give you. I was sitting in a chamber of a lawyer, my friend from school, and one client came to him. He was practicing on criminal side, and he said, look, I am not going to appear in your matter tomorrow because you have not paid fees for last 4 dates. So he said, you are not paying and you can take it and give it to somebody else. That client went away, and as we were sipping coffee, he came back and he gave 10,000 rupees to him. So my friend noticed that there was a mark, blade mark on all the notes. So he asked him, "Did you pickpocket?" So he said, "Sir, क्या करेंगे? करना ही पड़ा, आपने बोला कल appear नहीं होंगे. Now tell me," and write this example in the answer paper, whether that advocate professional ethics did he follow, and if followed, why, whether he is right or wrong. It is really amazing. Now one more thing, and I am done with it. Nodding the head. Now if you look at the several professional ethics books, you will always find when the judge is commenting in your favor, you will do yes, yes. And if the other side is saying something which is wrong, you will say. Now, according to several authors, nodding the head is against professional ethics. And I have seen Palkhiwala sitting for hours, day after day, in a matter when he was for the respondent. The other side was arguing, and he would not change expression of his face throughout the court hours. He would not nod, he would not smile, do nothing. And that is the highest standard of professional ethics. Like Sirvai in Krishna Water, he had come to Ashoka Hotel and he realized that there is a balcony for which the hotel is charging him 50 rupees more. So he told the hotel people, "I please change my room because unnecessarily the state of Maharashtra will be burdened with 50 rupees." These are the standards which existed years back. Now, of course, they are not there, but we have to develop ourselves in such a way that at least those standards are in our mind and they are reflected in our conduct. I think one quote, and I'm done. What is knowledge? Knowledge that we acquire is but as a torch flung into abyss, making the darkness visible and showing extent of our ignorance. So the knowledge is only a tip of the iceberg. We don't know how much more knowledge is there. So more you read, more you acquire knowledge. So don't even think that you will acquire the facts, the law without reading the brief. Put your heart into it, and I wish you best of luck for the exam as well as for the professional.
Thank you, Deepak, for sharing your wonderful your experience. I would just like to add here about the structure of paper.
Yeah.
Because unlike the papers which were given for the previous years, probably if we have changed the model, there would be objective type questions, 15 to 20 marks, and I'm sure most of the students will get all correct. We just need to focus on Bar Council rules, read them thoroughly. So that will take care of objective type questions. Then we have 10 mark questions, 6 or 7 of them, 5 or 6 of them, and options are given for 10 marks question. And we also will have 5 marks question. Again, options are given. Please try to complete the paper, at least aggregating to 100 marks. You did not attempt all optional questions, but attempt questions which aggregate to 100 marks. Please don't leave any question. Even if you can't write full answer, try to write your answer. At least write your points. It is the substance which would be important and not the form of your answer, not the length of your answer. It is the substance of your answer which will carry marks. And with this, we wish you all a very good luck for your upcoming exam. And thank you.
Thank you, Jay.
Thank you, sir. Thank you.
Thank you.